Good afternoon, everybody. My name is Patricia Alia. Welcome to CondoWise Learning Series. This is session number 9, the reality of cannabis legalization. I trust you had a great long weekend and a safe one. Today's topic is about the realities of cannabis use in condominiums and how we are doing with this introduction into condominium living. Today, we're glad to have Ashley Winberg, Julia White, John Wright, Megan Malloy, and Shannon Penny to take you from COVID to cannabis to case law. Today's advice is not legal advice, but is legal knowledge and guidance. We recommend always speaking to legal counsel about your specific condominium issues. So to get us started, Shannon is going to give us an update on the pandemic. Shannon, please go ahead.
Perfect. Thank you very much, Patricia. So good afternoon, everyone. So as we all know, Ontario remains under the stay-at-home order, which requires everyone to remain at home with the exceptions only for essential purposes. So the stay-at-home order is set to expire on June 2nd, but all existing emergency breaks and restrictions will remain in place until Ontario has entered into stage 1 of Ontario's reopening plan. So last week, the Ontario government announced a 3-step plan to reopen the province and said that step 1 of the plan will likely begin the week of June 14th, but they did confirm that a definite start date will be announced closer to that date. Ontario will remain in each step for at least 21 days to monitor the impacts on case numbers as restrictions are eased. So to enter into step 1, Ontario must wait at least 2 weeks after 60% of adults have received at least 1 dose of the vaccine. As of May 20th, the government did announce that Ontario had reached 58.5%. So step 1 focuses on resuming outdoor activities with smaller crowds. Non-essential retail stores will also be allowed to reopen with 15% capacity. Outdoor gatherings of up to 10 people will be allowed, and outdoor dining can also resume, limiting only 4 to a table. This first step will also allow restrictions to lift on camps, provincial parks, and outdoor pools and splash pads. So to enter into step 2, 70% of adults will need to be vaccinated with 1 dose and 20% vaccinated with 2 doses. So this step allows for indoor gatherings of up to 5 people, along with outdoor gatherings of up to 25 people. Outdoor sports and leagues can also resume, along with personal care services. Indoor religious services can also resume, again with a limited capacity of 15%, and retail restrictions will be further eased, allowing essential retailers to operate at 50% capacity and non-essential retailers at 25% capacity. In this step, Ontario outdoor amusement parks and water parks can also reopen, as well as outdoor live music events and attractions. So the final step would see a life return mostly back to normal, which we're all looking forward to, and can begin when 70 to 80% of adults have received at least 1 dose of the vaccine and 25% have received both doses. So larger indoor and outdoor gatherings will be allowed, though the province did not specify any specific numbers. So this step also includes a return to indoor sports and recreational fitness, indoor dining, and casinos. Across most regions now, individuals 12 and older are eligible to book their vaccine appointment. And in York Region, you may now also book your 2nd dose if you are a high-risk individual or a high-risk healthcare worker. Also in Ontario, if you received your 1st dose of the AstraZeneca vaccine between March 10th and March 19th, you're also eligible to book your 2nd dose. So just please remember that each region has different eligibility and are at different steps of the vaccine rollout. So it is important that you keep up to date with the information that's released by Public Health in your area. So I'll now pass you over to Julia, who'll be discussing reopening amenities and will be providing you with an update on a recent COVID case. Thank you.
Thanks, Shannon. So with the warm weather and gathering sizes slowly increasing, we understand that condos might start getting pressure from residents, if they haven't already, about reopening their amenities. Condos should start thinking about whether they can safely reopen some amenities, and if so, what steps need to be taken in order to do so. So we've talked about this a lot throughout our CondoWise series, and we've published a number of articles on our website about reopening, which might be helpful to review. However, generally speaking, in order to manage the risks of COVID-19 and reopen amenity areas, condos should have a fulsome COVID-19 protocol and policy in place, which relates to each amenity area, COVID-19 questionnaires to be filled out by all users who are entering those spaces, as well as liability waivers, and specific rules to be followed while using each space. So boards and management need to be thoughtful about limiting the number of individuals who can use the space at one time, which will depend on how large the space is and how it's set up. Cleaning and sanitization of the space before, during, and after each use. Whether the space should be redesigned to help reduce transmission. What kind of entry and reservation protocol will be utilized. What the screening process will be, as well as whether masks will be required while in the space. Most condos have already thought through reopening at least once over the past year. And if the condo already has these protocols, policies, and rules in place, it's a good idea to review them and confirm that they align with the new reopening response framework and are still adequate in terms of reducing transmission of the virus, given what we now know. It's also important to consider that there's now case law which permits condos to put in place rules which are more strict than what the government has put in place. And boards and management should review and understand what these restrictions are and how they translate to condominiums. So long as the tighter restrictions don't contradict what the government has put in place. The courts have also recently considered whether a resident's failure to wear a mask on the indoor common elements can be enforced and whether the same is a breach of Section 117 of the Act and therefore a dangerous condition. In the recent case of CCC 32 versus Yakovlev, which Jonathan Wright of our office discussed in detail in our last CondoWise seminar, the resident's failure to wear a mask on the indoor common elements was held to be a breach of Section 117, and they were ordered to wear a mask moving forward. The court said that the failure to wear a mask constitutes a risk to the health and safety of other residents, guests, and staff of the condominium. So this is a great case for condominiums in terms of being able to enforce its mask wearing rules and policies, but it's also important to keep in mind that there are human rights and accommodation questions that are relevant and still need to be considered for each case. So in terms of amenities, a distinction needs to be made between indoor and outdoor spaces. The outdoor amenities being pools, patios, playgrounds, and other similar spaces. As we've seen throughout the pandemic, transmission of the virus is less of a risk, generally when people are outside, where air is not recirculating through the space and where people can maintain a greater physical distance. At this time, there is nothing directing us to see that indoor amenities such as gyms or party rooms can or should reopen, but there may be flexibility for outdoor spaces, especially as we head towards stage 1 of the new reopening plan, where outdoor gathering sizes will be increased to 10 people and more outdoor activities will be permitted. So boards and management should be proactive, and if not already, start thinking about which amenities will be reopened first and what restrictions will be put in place for users of that space. As always, we recommend speaking with your legal counsel to determine which common areas can or should reopen, and if so, what policies, protocols, and rules should be put in place in order to make using those spaces as safe as possible. So I think we're going to head to a poll now, Patricia.
Yeah, thanks, Julia and Shannon. That was very helpful, and it's an exciting new plan. We'll see how well that works, but I'm glad to hear vaccines are rolling out. In the chat, there was an interesting point brought up by one of our attendees about when we're allowed to open more amenities, whether or not we'll be required to have a vaccine before attending things such as happy hours, coffee mornings, bingo, games, etc. That's a very interesting piece. It's very similar to a vaccine passport, which they're talking about for allowing people to go in and out of countries. CCI Huronia, when we just did our last update, we talked a little bit more in depth about vaccine passports, but generally what's interesting is that they really won't work and they will create an unfairness so long as we don't have the breadth of immunization across the board. So we really need to first establish the herd. And you can see even with the plan that the Ontario government's got going, opening up doesn't happen until we're getting that sort of herd immunity developed. So I think as well, we have to be thoughtful about whether or not it will be a basis for a human rights discussion as well, that if people don't have the vaccine or they don't have access, what are we really trying to show? We're really trying to show that the people who have the vaccine won't get seriously ill. It doesn't destroy the vaccine. So it's also about tying it logically together on the science. But now let's move to cannabis, which is our focus today. And I think we have a poll, Caroline, if you wouldn't mind putting that up. So is it reasonable to prohibit cannabis smoke, but not tobacco smoke at your condo? Interesting question. So if we could have all of you give us your thoughts. There's no right or wrong here necessarily, but Megan and Ashley are going to take us through how we can critically think through some of these concepts. Should we close the poll? So it's not reasonable to prohibit cannabis smoke, but not tobacco smoke at your condo. 75% are of that position and 25% are in the other field. So let's go now and talk about cannabis. Ashley, welcome. Good to see you. Why don't you take us through?
Hi, everyone. So currently cannabis is legal, and under the Cannabis Act, anyone in Ontario over the age of 19 is permitted to purchase cannabis from an authorized retailer, carry as much as 30 grams of cannabis on them, and consume cannabis in locations that are authorized by local jurisdictions. People can also grow up to 4 plants, which each can be up to 3 feet in height in a single given household. So that affects condominiums, because that means that in absence of a rule or a provision prohibiting it, residents can grow up to 4 cannabis plants in their unit. So what is currently prohibited? Well, under the Smoke-Free Ontario Act, no smoking or vaping is permitted in enclosed workspaces or in enclosed public spaces. That would include the indoor common elements to condominium corporations. Also, smoking and vaping is prohibited within 9 meters of any entrance or exit of a public building, which again would apply to any exit or entrance of a condominium. Smoking and vaping is also not permitted in children's playgrounds or 20 meters from a children's playground if 20 meters from is public space. And if there is any type of designated smoking area outdoors that has a shelter, that shelter can have no more than 2 walls if it has a roof. Under the Cannabis Act, individuals are also prohibited from growing those cannabis plants in public places. So arguably, residents in condominiums would be prohibited from growing plants in their exclusive use common element front or backyards, on their balconies, or really near any window that would be visible from the outside, so such that you could see the plants. And the Cannabis Act also prohibits large-scale grow-ops in individual residential dwellings. So what does this all mean for condos? Well, although large-scale grow-ops are prohibited, if someone were to grow up to 4 cannabis plants in their unit, this could have an effect on the corporation's utility consumption, and potentially, if corporation is not separately metered for utilities like water and hydro, this could have a disproportionate impact on others. Also, if an individual is growing cannabis in their unit, this potentially could increase the risk of mold or water damage, water escape, also potential fire or electrical hazards. So this could have an effect on the corporation's insurance premiums and potential exposure to liability. Now, recreational cannabis since the pandemic has been easier than ever to access. Every day I'm walking around and I'm seeing more and more cannabis retailers being authorized and opening. And because individuals are spending more and more time at home, this has all sort of led to an increase in complaints regarding secondhand smoke and odor caused by cannabis use. And Megan will touch base on what corporations can do using their existing restrictions, as well as additional recommendations as to how the corporations can target this particular nuisance and health concern. Megan, I'll let you take it away.
Okay, thanks, Ashley. Yep, I'm going to talk a little bit about the tools that can be used to address the restriction of smoking within condo communities, as well as what's probably not going to accomplish the job, especially if challenged in court. Most often, we will see these types of problems arise when a resident is smoking within a unit or on an exclusive use common element, such as a balcony or patio. And when this happens, there are already going to be some existing restrictions that can assist, even where a condo currently permits smoking in the units or on the common elements. So in addition to the Smoke-Free Ontario Act, which Ashley just spoke about, in Ontario, the Condominium Act 1998 imposes statutory obligations on condo corporations and their residents to comply with the act itself, as well as the condo's declaration, bylaws, and rules. Most condos' existing governing documents will already have some general nuisance or unreasonable interference clauses that have some application to enforce against smoking complaints. Usually the declaration or the rules will prohibit the creation of a nuisance that disturbs the comfort or enjoyment of the property by other owners. The board of directors will also have fairly wide discretion in determining what constitutes a nuisance, as long as their decision is within a reasonable range of choices. Some condos will also have provisions prohibiting anything to be done in the units that will increase risk of fire or to promote the safety of the property generally. And then in addition to the declaration and rules, Section 17(3) of the Condominium Act requires condos to take all reasonable steps to ensure that owners and residents comply with the act, as well as the declaration, bylaws, and rules. So if your condo is aware of a smoke issue that is violating either the act or the condo's governing documents, the board has a duty to investigate the complaint and, where necessary, to take steps to address the issue. Sometimes the solution to a smoking problem will be straightforward, and the condo can simply require the resident to change their behavior and take steps to ensure that their smoking isn't a nuisance to other owners. Unfortunately, there may sometimes be more serious deficiencies causing or contributing to smoke transmission, such as holes in the common elements or in the walls between units. So while it will depend on the circumstances, we do generally recommend that the board also take steps to investigate any smoking complaints to rule out larger possible deficiencies. And then where a deficiency is discovered, then the condo's declaration will set out who is responsible for the repair work and associated costs. And finally, we have Section 117 of the Condominium Act, which prohibits conditions or activities likely to damage the property or cause injury to an individual. Injury to an individual has been interpreted to include injury to the individual's health. So as secondhand smoke has been shown to be dangerous to health, then certainly a condo can use this provision to enforce against smoking issues. And also just to note, the proposed amendments to Section 117 of the Condo Act will actually change the wording to explicitly refer to an activity causing injury or illness to an individual, as well as will prohibit any prescribed nuisance, annoyance, or disruption to an individual on in a unit or in the common elements. So that hasn't come into effect yet, but when it does, I'm sure we're going to be seeing a lot more condos relying on that expanded wording. And then next slide, please, Caroline. So additional restrictions. While there are some existing provisions in the Act and most condos governing documents to equip a condo with tools to address secondhand smoke challenges, it is possible that condos who are seeing an increase in both secondhand smoke challenges, an increase in both the nuisance factor associated with cannabis smoke and complaints from affected residents are going to want to take steps to explicitly prohibit smoking within the units as well as on the common elements. Condos may also wish to prohibit the sale of cannabis or cultivation of cannabis plants, which is possible. Although realistically, it's going to be more difficult to enforce a restriction on growing cannabis plants unless they are emitting a strong odor or your condo's property manager plans on going door to door, doing spot checks to examine plants on a routine basis. So how to accomplish this? Next slide, please, Caroline. One way is to amend the condo's declaration to include a prohibition on smoking. Authority for this is found in Section 7(4)(b) of the Condominium Act, which provides that a declaration may contain conditions or restrictions with respect to the occupation and use of the units or the common elements. So a restriction that prohibits smoking, growing, or the sale of cannabis would most appropriately be found in a condo's declaration. Unlike rules or bylaws, provisions contained within the declaration are not subject to a reasonableness standard, or in other words, are not required to be reasonable. So the condo will have wide discretion when drafting the prohibition. The procedure to amend the declaration is set out in section 107 of the Act. And generally, the board will need to pass a resolution approving the proposed amendment. It must then call and hold an owners meeting to consider the amendment. And then the condo must obtain the consent of 80% of its owners in writing in order to proceed with the amendment. And then the amendment will not be valid until it is registered on title to the condo's units. Generally, obtaining the consent of 80% of the owners will be the biggest hurdle in passing the amendment, especially if there's a significant number of smokers in the building. So while it is possible to proceed in this way, if you don't believe that getting 80% of the units to consent is an attainable goal in your condo, then passing a rule prohibiting smoking is probably the best way to start making the transition in your building. So next slide, please. Thanks. So rules, under section 58 of the Condominium Act, a condo can create rules to promote the safety, security, and welfare of residents and the property, or to prevent any unreasonable interference with the use and or enjoyment of the units. Unlike the declaration, rules passed by condo boards must be reasonable and can be challenged if they are not. So any rule should have a logical and rational basis. For example, as was raised in our poll question today, if your condo plans to ban the smoking of cannabis, but currently permits the smoking of tobacco, then it should consider banning both substances simultaneously, as both are legal, and it is arguable that both cannabis and tobacco smoke is equally disturbing. So generally, implementing new rules is going to be easier than passing a declaration amendment. To proceed, the rules are drafted, usually by the condo solicitor, and then passed by the board, and then circulated to the condo's owners, who then have 30 days to requisition a meeting to challenge the rules if they disagree with them. When a meeting is requisitioned, then a vote on the rules will be held, but if no requisition is made, then the rules will be effective after 30 days after circulation. So generally, this is the fastest and most straightforward way to accomplish a smoking or growing prohibition. And I'm not going to get into bylaws today. While they're not as typical in these circumstances, I also just want to mention that it is possible to pass a bylaw prohibiting smoking, growing, or the sale of cannabis. I actually did this just recently for a client. A bylaw, however, will not be effective until a majority of the unit owners vote to confirm it and until a copy of the bylaw is registered in the appropriate land registry office. So again, not as straightforward as passing a rule, which is usually the preferred method by most condos we act for. And finally, I just want to mention that fines are also prohibited under the amendments to the Condo Act. So if your condo is currently handing out fines to smokers or using them as a deterrent, you should just be aware that in the event of a challenge, they are likely to be found unenforceable and will not be upheld. And I think we're back to Ashley for grandfathering.
All right, so if a condominium corporation decides to prohibit smoking, and just to be clear, there's a variety of different ways that one can consume a cannabis. It can be smoked, vaped, and it's now available in edible forms from authorized retailers. The edible forms, I mean, if someone consumes like cannabis on the common elements in a gummy, that's not really going to have an effect on others while using the common elements, unless the person is essentially like intoxicated to a similar extent. So really, when we're talking about addressing cannabis, we're talking about prohibiting the smoking, growing, potentials, or restricting smoking, growing, the sale, production, and vaping. So if your condominium is considering, imposing stronger restrictions when it comes to smoking and vaping, before it does so, there's three things it needs to consider. The first is grandfathering, and essentially, regardless of the alternative selected by a corporation when prohibiting smoking, it's recommended that the rule or deck amendment include a prohibition that permits current residents who currently smoke to continue to do so for a set period of time or until they sell and move out of the building. Now, although this permission would mean that it would take longer to convert a building into being smoke-free, it will assist with getting residents or owners to approve the declaration amendment or not challenge any potential rule that the corporation may create. Now, these grandfathering agreements, we recommend that they be included as a schedule to the rule or the deck amendment. And in that declaration or grandfather agreement, my apologies, it would contain, various requirements that the grandfathered resident and unit would have to comply with, such that they won't be able to smoke in their unit in a manner that causes a nuisance or reasonably interferes with others' use or enjoyment of the property. And Caroline, if you could just change the slide, please. The second consideration is a designated outdoor smoking area. And I think this is really important because if the corporation prohibits smoking in the units and on the common elements, smoking isn't going to be permitted at all on the property. So I recommend that any deck amendment or rule that prohibits smoking contain a provision that provides the board with the authority to designate an outdoor smoking area from time to time where individuals can smoke. By providing the board with the authority in that deck amendment or rule, they have the ability to create that designated smoking area if they want, but also the flexibility not to create it if they don't want to. Why do I recommend that corporations create outdoor smoking areas? Number one, if you're going to prohibit smoking by way of a rule, it makes the rule more reasonable and then less susceptible to challenge. And number two, regardless of whether it's via a deck amendment or a rule, by creating a designated outdoor smoking area, it will help promote compliance. And that's ultimately what we want. For example, if a corporation prohibits smoking in units and exclusive use common elements, if a resident has a guest over that smokes and the corporation does not have a designated smoking area, that resident may be more inclined to let their guests smoke on the balcony. However, if there was an area where their guests could go and smoke, they likely would comply with the rule and join their guests in the designated outdoor smoking area. However, not all corporations can construct designated outdoor smoking areas because there might be certain limitations in their property. Under the Smoke-Free Ontario Act, if the corporation is going to construct like a shelter, it can't have more than 3 or 2 walls if it's going to have a roof. If it doesn't have a roof, there's no restriction on walls. Also under the Smoke-Free Ontario Act, the designated smoking area must be located a minimum of 9 meters away from any entrance or exit and 9 meters away from any playground. So some corporations don't have sufficient room to create a designated outdoor smoking area. And the third consideration, Caroline, if you could please change the slide, pertains to medical cannabis and really human rights. So the Ontario Human Rights Code could be used to allow cannabis smoking and vaping as well as prohibiting it. So in the first instance, let's say the corporation prohibits smoking in the units and on the exclusive use common elements. A resident might approach the corporation and say that they have a medical condition or a disability under the Human Rights Code for which they require the use of medical cannabis that must be consumed. They can't consume it any other way. In this particular situation, the corporation may be required to accommodate the resident up to the point of undue hardship. And that might require that the corporation permit the resident to smoke medical cannabis on the common elements, on the exclusive use common elements, or in their unit. When it comes to the general common elements, it's also important to note that there is provincial legislation which provides exemptions for individuals who consume medical cannabis vis-a-vis smoking from the provisions of the Smoke-Free Ontario Act that prohibits smoking in public spaces. So arguably, if someone has a medical condition for which they need to smoke medical cannabis, they could arguably be permitted to smoke the medical cannabis on the general common elements. However, they'd have to be accommodated under the Human Rights Code and provide medical documentation establishing that they do in fact require accommodation. So in the alternative and second instance, if the corporation were to allow residents to smoke cannabis in their units or on their exclusive use common elements, it is possible that another resident could say, well, hey, I suffer from a medical condition made worse by the presence of secondhand smoke, for which I require accommodation. And this was an argument made by an applicant in a BC Human Rights Tribunal decision. And in that particular decision, the applicant said they have a pre-existing health condition made worse by the presence of secondhand smoke. And the tribunal held that the corporation failed to accommodate those applicants by failing to enforce its existing bylaw that prohibited owners from causing a nuisance. So when it comes to medical cannabis and the duty to accommodate, the code could really be used to prohibit and to allow the smoking of cannabis. So that's why it's really important that all condominium corporations have a human rights policy in place, so that any accommodation requests are handled in a timely manner, which limits the corporation's exposure to potential liability and ensures that anyone who is entitled to accommodation receives accommodation without undue delay. Now, let's say the corporation has received a complaint about secondhand smoke or odor. Now, under the Act, the corporation has an obligation to take reasonable steps to ensure compliance with the Act, declaration, bylaw, or rules. However, nuisance disputes, when it comes to secondhand smoke or odor, are particularly problematic because it's difficult to sometimes determine the true extent and source of the nuisance of secondhand smoke and odor. It's also difficult to determine whether or not there is a dispute because people have different sensitivities with respect to smoke and smell, and also it's difficult to ascertain the correct facts. So in absence of any clear facts, it's always important that corporations take a cautious approach and not err on the side of caution. And that's why it's critical that condominiums take an unbiased and neutral tone in their approach in dealing with scenarios like this. Now, so that's just overall. The first thing that a corporation needs to do once it receives the complaint is investigate. So there's two things that the corporation really needs to look into. The first is the source and extent of the complaint. So the corporation needs to assess and try to identify how the smoke is entering a particular unit. Is it coming through an open window, from a bathroom, kitchen, or fan, through an outlet? The corporation also needs to try and identify where the smoke is coming from. Is it coming from a neighboring balcony or another resident smoking within their unit? It's also important for the corporation to try and find out how often the smoke enters the unit. So how often the individual is complaining about the secondhand smoke or odor, whether they smell it at certain times of the day, and how often it is occurring. And that's also important for the corporation to try and find out, when the problem started. Did the problem start when someone potentially moved into the building, or when the resident moved into their unit? That's what the corporation needs to try and look into. And the second thing that the corporation needs to investigate is the impact of the secondhand smoke and odor. So the first thing, the corporation needs to determine whether or not the secondhand smoke and odor is an objective nuisance. So they need to try and find out, the resident that is complaining of the secondhand smoke and odor, are they able to live in their entire unit, or is certain portions of their unit seriously affected by the secondhand smoke or odor such that they're unable to use those areas of their unit? Are they able to use their balcony? Are they able to keep their windows open in the summer without being bothered by the smoke? And the second and most important is the corporation needs to assess whether there's any potential and negative health consequences as a result of any potential secondhand smoke. So the corporation needs to find out whether there's evidence of any actual harm or a threat of potential harm. So this is very similar to the applicants in the BC tribunal decision that I discussed. So if someone is complaining about the presence of secondhand smoke, it's important that a corporation, and if they say that they have a medical condition made worse by secondhand smoke, it's important that the corporation request medical documentation from that individual to support their claim to find out whether or not the corporation has a duty to accommodate that individual in a timely manner. The third thing a corporation needs to do after it has investigated is try and mitigate any potential transmission. So the corporation has an obligation to mitigate, as well as the owner and resident of the unit where I guess the smoke is allegedly emanating from. So under the Act, the corporation has an obligation to maintain the common elements and repair them after damage. So the corporation needs to inspect the units at issue, as well as the adjacent and surrounding common elements, to find out if a common element deficiency could be potentially contributing to the transmission. And the corporation also needs to speak with the owner of the unit and the individual allegedly smoking to find out if they can modify their smoking habits and seal the unit to ensure that to minimize smoke and odor from transmission being transmitted as much as possible. In preparing for this presentation, I also looked into HEPA filter recovery ventilation systems, and there's a potential that those could also be installed in units to keep them pressurized to prevent air transmission and secondhand smoke. I know we're running short on time, so when coming up with solutions, it is important that corporations and all the individuals involved work together, be open to alternative solutions, and exchange pertinent information, and know when to engage the assistance of professionals. There was recently a case where a corporation grandfathered or passed a rule grandfathering, passed a rule prohibiting, and then allowed owners to submit a grandfathering request. It denied an owner's grandfathering request, and refused to meet with the owner to discuss potential solutions. And ultimately, the court ruled against the corporation and ordered that the individual be grandfathered nonetheless. And then it's important to follow up once any solutions have been implemented. And then if those solutions are not working or people are not complying as required, then seek legal intervention. And now I'll turn it to Megan.
Thanks, Ashley. So legal intervention, that's where we come in. Once a condo has attempted to address the issue internally, but the owner or resident is unwilling to comply, then the issue will be escalated to the condo solicitors. So enforcement letters, while we will address each situation and provide recommendations on a case-by-case basis, generally our practice is to send 3 enforcement letters to the offending owner and or resident, detailing the history of the issue, setting out the relevant legal authorities, and requesting their voluntary compliance. Most of the time this works and we can come to an agreement, but where it doesn't, it sometimes becomes necessary to escalate the matter. Mediation. Section 132 of the Condo Act requires mediation where there is a disagreement between the parties with respect to 4 particular instruments, namely agreements, declarations, bylaws, or rules relating to the condo unit. However, Section 132 of the Act has no application to breaches of the Act itself. So condos are actually not required to submit disagreements with respect to breaches of the Act to mediation and arbitration. So if your smoking matter substantially concerns a breach of Section 117 of the Act, then there is no mandatory duty to attempt mediation before proceeding to court. However, depending on the circumstances and the positions of the parties, we sometimes will recommend that clients attempt mediation, or will even host an informal mediation between the parties, which can often help to resolve matters without involving the court and will avoid the incurrence of substantial legal costs. And then finally, if all other attempts at seeking voluntary compliance fail, then a condo can bring an application under Section 134 of the Condo Act, which permits a condo to apply to the Ontario Superior Court of Justice for an order enforcing compliance with the Act or the condo's governing documentation. As Ashley noted, it is very important to document the issue in as much detail as possible, as we will need to rely on the condo's evidence if we're proceeding to court. The problem with smoking issues is that odor and smoke can be fleeting or transitory. So the more evidence that a condo has that we can provide to the court, the better. Generally, we will also ask the court for an order under Section 134(5) of the Act that permits the condo to recover 100% of its legal costs in seeking compliance. So the goal will be that the condo is not out any money at the end of the day when the matter has concluded. And finally, keep in mind that all enforcement steps taken by a condo must be reasonable. In order to demonstrate that a condo acted reasonably and did not immediately escalate the matter by rushing to court, we recommend attempting to work with the owner or resident first, and that there be as much communication as is possible in the circumstances to determine whether there is a simple and cost-effective solution. And you can definitely speak to your lawyer or give us a call about how to accomplish that. So that's it for me. I think we are now moving on to Jonathan with the case law update. So over to you, John.
Thanks, Megan. So just continuing on from what we've been discussing this morning, I wanted to look at two cases involving enforcement and the outcome of those cases and how they can be applied to regulating cannabis and the realization of cannabis being introduced to condominiums. And the first case I want to look at is TSCC 2032 versus Boudair and Dong. And in this particular case, Dong was the owner of the unit and Boudair was the tenant. And Megan just finished speaking about reasonableness and how to potentially bring about compliance by acting reasonably prior to going to court. And this case really touches on that. In this particular case, as a tenant, Boudair was required to comply with the corporation's declaration and rules. And although the decision does not specifically mention that there is a no smoking rule in place, the tenant had expressly agreed not to smoke. So the tenant moved in. The neighbors started complaining about smell of smoke coming from the unit. The owner was warned. He apparently advised the tenants to stop, but the complaints continued nonetheless. There apparently was a bit of a back and forth between the owners and the tenants. More warning letters were sent from the corporation asking the tenant to stop. The tenant continued. 2 months after the first letter was sent, the corporation then commenced an application seeking compliance under Section 134 of the Act. Only after becoming aware of the court application did the owner then terminate the tenancy with the tenant on a voluntary basis. Previously, the tenant had demanded some compensation for the early termination, but when the court application was commenced, that was dropped. So the matter was resolved, all but the legal fees. So the parties went to court. The court was then asked to determine whether or not the legal fees requested by both the corporation, who wanted $32,000 from the owner, and the owner's legal fees, and the owner wanted $25,000 from the tenant. And unsurprisingly, the tenant not wanting to pay anybody should be awarded. In the end, the court awarded $10,000 to the corporation and $10,000 to Dong. So the court, in reasoning the decision, agreed that the corporation had a duty to control and manage and administer its common elements and to take all reasonable steps to ensure that the owners and occupiers complied with the Act, declaration, bylaws, and rules. However, the judge confirmed that the corporation could seek the costs resulting from a tenant's breach, but it was not a case of strict liability. That is to say that the owner was not automatically on the hook when the tenant breached the rules. The court went on to describe the fact that the owner must be advised of the issue and the owner must be provided with a reasonable opportunity to resolve the issue with a tenant. The court looked at reasonableness and what was reasonable. We just heard Megan talk about that. And what is reasonableness in compliance matters? From this case, it appears that reasonableness includes, where tenants are involved, sharing relevant information obtained by the corporation with the owner. Mr. Dong, in this case, argued that he was not provided with all the information that was in the possession of the applicant. And if he had been provided with this information, he could have secured an earlier termination to the tenancy on a voluntary basis at a much sooner opportunity. The condo argued that it was clearly the pressure from the pending court date that caused the termination in the voluntary eviction, and that Dong simply should have started this eviction process much sooner. The court agreed with Mr. Dong. The court, in doing so, said that even if Dong had started the eviction process earlier, which I find was not necessary, as it was reasonable to try and conduct good faith negotiation with the tenants, there was no guarantee that the tenants would have been formally evicted prior to the return date of the application, or at all. I find in Dong's submission that he likely could have secured the tenant's consent to an early termination of the lease sooner had he been provided with the additional documentation or information in the applicant's possession. The court found that the applicant essentially jumped the smoking gun by moving for a compliance order. So what I would like you to take away from this particular case is that the court will look at the pre-litigation conduct between the parties, as Megan had said, the reasonableness of your actions. condos and their legal counsel can and are in fact encouraged at an early stage, especially when there's tenants involved, to work with owners and to assist owners before going to court. Now, acknowledging that's not always possible. Some owners can be very difficult, may not want to work with you at all, deny anything is happening, and that's fine, but the attempt should be there and the documentation should be there. Also, there's a discussion in this case, as I mentioned, about sharing information. And although there is that sort of narrative that the information should be shared, before doing so, we would ask that you consult with your legal counsel before sharing information. There is certain information that can be privileged and should not be provided, which can constitute a waiver of privilege, but your lawyers are more than apt to advise on that, I'm sure. The second case I want to touch on very briefly is a recent CAT decision. If Carolyn, I could ask you to change the slide. Thank you. And it concerned the enforceability of a policy versus a rule. And it's maybe a cautionary tale for those that don't have, for example, a no smoking or a no cannabis policy in your condo, and you may try and pass a policy instead of a rule. In this case, as you'll see from the slide, is Boodram v. Peel Standard Condominium Corporation 843. So this case involved an attempted enforcement of a visitor parking policy. But although it's visitor parking that we're talking about here, the same principles can be taken away and imported into other situations such as smoking and cannabis. So in this respect, I don't want to focus very much at all on whether there was a breach of visitor parking provisions, but instead to focus on the narrative and discussion between policy and rules and how the CAT broke down the difference. So in this case, the CAT found that what was actually in play was not a policy at all, but it was a rule, and a rule that was not enacted in accordance with the Condo Act. And the result, which resulted in the condo essentially losing the proceeding and being ordered to pay the filing fee back to the unit owner, and the condo also being ordered to cease enforcing its policies related to the particular policy until the same was enacted under Section 58 as a valid rule. So what are the differences between policies and rules? The Condo Act doesn't actually include any mention or reference of policies, but the court has nonetheless recognized the validity of policies. In fact, there's two very recent court cases dealing with the current pandemic, and the courts have recognized that the enactment of health-related policies during the COVID-19 pandemic is an appropriate exercise of that authority. As policies aren't described or legislated for in their act, there is no requirement to circulate a proposed policy to the owners. There's no procedure for voting or challenging a policy. And this intrinsically makes a policy easier to adopt than a rule. And this case makes it clear that if a policy is in fact a rule, the policy is not going to be enforced either by the CAT or presumably the Superior Court. The tribunal stated that a policy can provide a consistent and reliable framework for condos to guide its conduct and conclusions in decision-making processes. And the tribunal also gave a helpful example of such a policy being the compliance policy, when to escalate matters, how many steps need to be taken before matters can be escalated. That's a valid policy. Another valid policy that our office often recommends is a human rights policy, how certain accommodation requests can be made. Other policies can be communication policies, things like that. Rules themselves are required to be reasonable and to meet the criteria set in Section 58 of the Act. And this means rule must either serve the purpose of either promoting the safety, security, or welfare of the owners, the property and assets of the condo corp, or to prevent unreasonable interference with the use and enjoyment of the unit's common elements or the assets. So my takeaway from this, when considering whether you want to impose a new rule or a policy, it's important to consult with your legal counsel before embarking on the process. Although you may think that a particular policy is not restrictive in any manner and it doesn't deal with any new particular issues, there may be certain nuances of that policy that would be akin to a rule and require the process set out in Section 58 of the Act. So in that respect, again, we'd ask you to consult with your legal counsel. Thank you very much. And Patricia, I'm turning back to you.
Thanks very much, John, and I appreciate the overview, everybody, on cannabis and case law. I'm going to post as well for our audience and for the panel an interesting case. It's called the Queen and Savory, or Savory. I'm not sure how you pronounce it, but it was interesting because the Crown proved beyond a reasonable doubt that the accused had recklessly caused damage to the condominium contrary to the criminal code. And what he was doing is he was extracting cannabis resin in the condominium suite. So he actually set it on fire. He actually was injured. And so, I think it's important to set really clear, reasonable parameters around behaviors, especially when people start getting creative on how they're going to use cannabis in their suites and whether or not that really presents a threat to people around you. So I'm curious because we do have time for a few questions, and I noticed that there were 2 questions from one of our participants in the Q&A. So this is what the participant has to say. We have cannabis and smoking rules in place. How do we, I guess, prove that smoke is coming from a specific unit when complaints are made by other owners so we can take action? So Ashley, I'm going to ask you, do you think I have some reflections on that?
I'm not a property manager, but in working with a property manager on a very similar situation, I learned that there are actually specialists that the corporations can retain to conduct specialized smoke tests to try and ascertain where the smoke is coming from. And perhaps we can do up an article or a follow-up to this webinar with that additional information. But I am aware that there are some specialists that corporations can retain to do smoke tests to try and find out where it's coming from. But if it's coming from, someone's balcony and it's coming through the windows, that's a little bit more difficult to find out. But it's just really important that whomever is complaining about the smoke just try and provide the corporation with a log as to, the dates and times, and that might help the corporation narrow down its search.
Great. And Megan, what do you think in terms of, as a litigator, what kind of evidence do you want to see in front of you?
So yeah, as I said, I think the more evidence, the better. Some things that we previously suggested to clients in these circumstances are that every time a condo receives a complaint, the condo should have their security or concierge actually go right to the unit as quickly as possible once the complaint is received, or I guess the suspected unit. But if someone on the corporation staff can actually verify, as a secondary verification that the smell or the odor or the smoke is coming out of that unit, then that will help to, bolster any complaints that are received. So it's not just, he said, she said, but it's actually someone's complained, it's been verified, and the condo should actually have their security keep a log of all of those complaints and verifications as well. So if we can present something to the court saying, yes, we did get the complaint, yes, it was verified on security at this date and time, then that is more substantial evidence, certainly, that we can use to present to the court to prove that it is actually the person violating. And then finally, I guess, as circumstances merit it, condo can also provide notice that they're going to go in and do an inspection of the unit. Again, as smoke is kind of transitory, this may not assist, but there, would be circumstances where perhaps you'll be able to find something indicating that someone is smoking within that unit as well.
Well, thanks. And, I think it's also important to recognize this other issue, which is if there's smoke coming through the common elements, this also engages the condominium's responsibility. So one of the important things is to see with the smoke test, it shows you how well sealed the unit is. And if there is proof that the unit is not well sealed, then one of the first steps may be for the condominium corporation to actually do the work of sealing the unit. There's another great question here. Can condos ask for proof from owners of requiring medical cannabis? So I guess the question is, can you ask somebody about their medicines and their uses? So Ash, since you love human rights, tell me, what do you think?
Yes, you are entitled to request medical documentation from that individual that details their medical condition and specific as to why they need to consume medical cannabis vis-a-vis smoking. However, any documentation and information received must be held in strict confidence and only used for the purpose of exploring accommodation solutions.
Yeah, and I think Section 55 is very important to always remember, but it's good to have a policy in place on information management, how you're going to hold, these kind of pieces of information, close to you. So I wanted to ask John, Amlani is one of these cases I know that you've been talking a lot about, John, and And that had to do with smoking, and that had to do with enforcement. And I believe the case started about nuisance. That was the sort of novel approach here. But at the end of the day, there was this other issue about the indemnity and making sure that the deck was fulsome. So, John, I think you can't just have a good case. You just can't get a judgment that shows, you were right. There's also a cost associated with litigation. So what do you think is important here in terms of effective compliance all the way through in accordance with the Act?
I think the issue in Amlani really came down to the wording of the indemnity provision, as you mentioned, and the condo tried to enforce or charge back costs that they were, on the reading of the declaration, were never really entitled to charge back. And the court said that if they want to charge back, they're going to have to pursue it, in a different manner, essentially. So I'm not sure exactly what your question is, Patricia. Do you mind rephrasing it a little bit?
Well, I'm just thinking, in Amlani, so there was this dispute, and it proved that Mr. Amlani had sort of done a lot of work, and I think the court was sympathetic to that. And then, there was also this threat about charging back, right?
Yeah.
And it found that, the indemnity wasn't broad enough.
Yeah.
And this case has really highlighted most recently a distinction. It hasn't changed the law, but it has highlighted a distinction. And so, for me, what I'm thinking is, as a litigator, what kind of indemnity do you want to see, John?
In order to lien anything, an indemnity that provides for all costs incurred as a result of, for example, a breach of the rules, deck, or bylaw, that would allow for the condo then to say, okay, we incurred costs in dealing with your lack of compliance. Here's what we've incurred. We're liening you for this amount. It has to be broad. It can't be simply just with respect to the common elements if you're trying to enforce, for example, a noise complaint and to try and lien for that particular chargeback. I think there's a very strong argument to say that, well, noise complaints aren't strictly to do with the common elements. In Mr. Amlani's case, it was to do with smoke and smoking, and the condo liened for their chargeback, and that wasn't too well received by the court. So one of the things that I spoke about recently in a CCI event, the speed dating event, was really beefing up and reviewing your indemnity clauses in your declarations. A lot of them simply refer to, with respect to the common elements, is the wording we see most commonly when they're limited indemnity. And certainly, I know you and I have discussed this, Patricia and Richard and some other colleagues, to try and broaden indemnities as much as possible, including things like trying to include cat costs, trying to include human rights costs, defense costs, things like that, really to include as much as possible to ensure it's not innocent and compliant unit owners that are carrying the cost of the few that don't want to comply.
Right. And I think technically it takes time to get that in place. If you don't have a robust declaration indemnity clause, it takes time to get those approvals, and it's a consent process. So you have time to do it, but it's better to be thinking ahead, making it broad, because we know that these options and these elements are there, and we want to be able to get compliance costs back. Because, I really do think the Act is drafted on a consumer protection legislative basis, which is that if I didn't do something wrong, I'm not sure why I'm picking up the cost. I know societally there's a value in seeing enforcement, in making sure there's compliance, making sure there's no breach of the rules, and not, boards not being exposed to claims of oppressive conduct. But, I can see boards being hesitant if they're not going to get back their costs. And that would create a bigger jeopardy, in my opinion. And I think it's more important that, as well, if you're the unit owner that didn't break the rules and you were told very clearly you're breaking the rules, I'm not sure why I personally, as a unit owner or director, am bearing that cost. So there's another question. Thanks, John. Are there any tests you can use near the front door on the corridor that you can find out for sure that this is the unit is the source? That's an interesting, very specific question. I think it's trying to figure out if you can obtain data. Megan, have you heard of anything like that?
I think they can do something that's called a popcorn test, where a contractor will go in the unit and effectively the unit is sealed and they pop a bag of popcorn or something along those lines. And then if you can actually smell the odor in the next unit or the complaining unit that's next door, then that's one way to determine it. I've heard of that used and seen that used before. I'm not sure if Ashley has experience with any other ones, but it's some sort of test where effectively a contractor will go into the unit and create or replicate some sort of odor, and then they can kind of trace where it travels.
Yeah, and I think the hallways might be a bit of a challenge, right? Because hallways are actually pressurized to put air pressure back into the units so that there's less transmission of smell. I think it's really more between the units that you're concerned with that transmission issue. Ash, did you have any other sources or any other tests that you know of?
No, the similar test that Megan described, I guess the smoke test or odor test to determine.
Okay, so I have one last question. This is bugging me. How far can grandfathering rules go? Like, can people agree to sell their unit if they're breaching? And this is hypothetical, guys. This is not a legal opinion, so you can give me what you're thinking. I'm just curious.
You mean if someone breaches a grandfathering agreement?
Like how far can your grandfathering agreement go?
Well, I think when you first start with revoking the grandfathering, so you no longer have the privilege to smoke. And then if you continue to violate, then for sure you would escalate the matter. And potentially if it goes to court, you'd seek an order that A, they comply, and then B, or in the alternative that they sell their unit. I think in the circumstances, depending on the seriousness, the court's probably not going to order that they sell their unit off the bat. But if there is a compliance order awarded, then certainly if that is breached, then the next time we would go to court, we would ask that they're forced to sell the unit because obviously they've failed to both abide by the acts, the governing documents, a court order. So there's more serious conduct warranted to justify that order. But again, I think the conduct required to force the sale of a unit is very high. So you'd have to discuss that in their particular circumstances with your lawyer.
Okay. Any other thoughts, John, Ashley, on how far you can go?
Well, I think it has to be specific to the unit and to the resident. So I've seen in some situations, some residents or tenants, they've gone from one unit to another. So if the corporation steps to the board, really, if they want to provide that latitude, that can happen.
Okay, well, thanks everybody. It was so great to have you here, Julia, Shannon, Megan, Ashley, John, and Caroline for keeping us on time. Thank you everybody who participated. It's wonderful to have you with us. Just want to remind you that the CCI National Leaders Forum is this week and the National Conference is on Saturday. Please take a look at Ali Associates website for all the CCI dates that are coming up in your chapters, so you can see what other in-depth learning is available to you with industry professionals through CCI. So thank you, stay well, and hopefully you have a chance to get out and get the vaccine because that'll all help us normalize this new normal. Take care, bye-bye.